Assalamualaikum Pak Syaifuddin. Mr. Syaifuddin.
Waalaikumsalam, Prof.
How many participants?
Now is 37. Usual is 100. But maybe we will start in 10 o'clock. Maybe.
How many? How many participants?
Usual 100.
100. Oh. So right now still 40 participants.
We can start in 9 o'clock.
Okay. We will wait.
7 minutes until 9 o'clock.
Okay. And we have time schedule until
10:40.
10:40. Wow, too long.
Maybe 100 minutes. Yes, from 9 o'clock to 10:40.
Yes.
Prof. Aidul, may we start now?
Insyaallah.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam.
Assalamualaikum warahmatullahi wabarakatuh.
Alhamdulillah, nahmaduhu wa nasta'inuhu wa nastaghfiruh wa na'udzu billahi min syururi anfusina wa min sayyiati a'malina may yahdihillahu fala mudilla lahu wa may yudlil fala hadiya lahu. Asyhadu an la ilaha illallah wa asyhadu anna Muhammadan abduhu wa rasuluh. Rabbi shrah li sadri wa yassir li amri wa hlul 'uqdatam min lisani yafqahu qawli. Amma ba'du. Good morning, ladies and gentlemen. Welcome to International Short Course with the title The Dynamic of Islamic Law. The topic today is the religious court system in Indonesia. I am Syaifuddin Zuhdi as moderator for this session. Before going further into the main session, I would like to warmly welcome today to speaker Prof. Aidul Fitriciada Azhari, S.HI M.Hum from Universitas Muhammadiyah Surakarta, as well as participant today from the International Short Course. Thank you so much for joining us today. Before we get started with the main session, I'm going to explain some rules to ensure the participant can interact with myself as moderator and the speakers. Firstly, the presentation will last for approximately 1 hour from speaker and 40 minutes of question and answer. During the presentation session, I would like to ask the participant to keep mute their respective Zoom account so as not to interfere with the presentation. Secondly, if you wish to ask the speaker's question, please use the raise hand feature on the screen, or you also can use chat feature to give the question, and I will have to wait it to speakers. The speaker today will be Professor Dr. Aidul Fitriciada Azhari, S.HI M.HUM. Good morning, Prof. Who are you today?
Good morning. Assalamualaikum warahmatullahi wabarakatuh. I'm fine today. It's okay. Yeah, everything okay.
I like to read a brief introduction to our speaker. The curriculum vitae of Professor Dr. Aidul Fitriciada Azhari. The full name, Professor Dr. Aidul Fitriciada Azhari, S.HI M.HUM, born in Tasikmalaya, 1 January 1968. The history job is Professor Dr. Aidul Fitriciada is the Dean of Faculty Law in UMS. So the head of Judicial Committee in the Republic of Indonesia, and now headmaster of Magister Legal Studies in Universitas Muhammadiyah Surakarta. Today, Professor Dr. Aidul Fitriciada Azhari will talk about the religious court system in Indonesia. So, without any further, let's begin the presentation session. Prof. Aidul, time is yours.
Thank you, Mr. Syaifuddin. Assalamualaikum warahmatullahi wabarakatuh. Good morning, everybody, ladies and gentlemen. Right now, I would like to presentation about religious court system in Indonesia. It is the difficult topic for me because basically I am my background is constitutional law studies. So in my explanation, I would view based on the constitutional perspective, not from the Islamic law perspectives. It is a disclaimer. Okay, we start with share screen. Religious court system in Indonesia. This is topic of our lecture today. Yeah. The systematic representation. We will study about the first introduction, so legal study, legal basis, principle, history. So we will study about Indonesian judicial system in general, and after that, structure of religious jurisdiction, and a little bit procedural law of religious courts. Right. For introduction, the religious courts is one judicial bodies, or in our in the 1945 Constitution, judicial bodies is like a circles of courts. In Constitution, when we call lingkungan peradilan. So in English, we use judicial bodies or judicial circles, which underneath the Supreme Court. So the position of judicial bodies, religious court, as the religious court is under the Supreme Court, that established based on the Indonesian Constitution. We call the 1945 Constitution. According to the Constitution, the judicial power shall be independent. This is the main principle in our Constitution for judicial power, and shall possess the power to organize the judicature in order to enforce law and justice. So the purpose of judicial power, the organization of judicial power, or the governance of judicial power, is to enforce law and justice. Law and justice. Law is refers to our legislation, our regulation, and justice refers to virtue, the good virtue, the values in our system, particularly justice based on Pancasila. The judicial power in Indonesia shall be implemented by Supreme Court, by one Supreme Court, and judicial bodies, and judicial court. There are 4 judicial courts in our system, in Indonesian system. That are general court, religious court, military tribunal or military courts, and administrative courts, and by one constitutional court. So there are 2 to actor in our in judicial power in Indonesia: Supreme Court and Constitutional Court. However, Supreme Court, there are judicial bodies under Supreme Court, that there are general courts, religious, military, and administrative courts. And then in religious court is a judicial body with jurisdiction to hear and decide the legal affairs between Muslim people. This is special court, but not special court in a special court in I think in Indonesia, because in our words, there is a little nation, little country that have a religious court as Islamic courts. And Indonesia, religious court is judicial body that established for hearing and deciding the legal affair between Muslim people. And between Muslim people is special affairs for religious courts. Religious court has jurisdiction generally to hear the Islamic private cases, Islamic private cases. However, particularly in Aceh, has jurisdiction to trial limited criminal cases. So in the years and generally, the jurisdiction of your religious court is Islamic private cases. But in Aceh, based on a special law, the special law about Aceh, concerning province of Aceh Darussalam, there is jurisdiction to limited criminal cases. We call in Islamic criminal cases, or jinayah. And historically, religious court is the oldest court in Indonesia that established before Dutch colonial came to Indonesia. That is clear, because before Dutch colonial came to Indonesia, the Islamic law and Islamic courts have access in Nusantara, or in Muslim people in Nusantara. And okay, we will study about historically in particularly in history of religious courts. This is legal basis. Of course, many legal basis, but I refer to several basis, legal basis, particularly the Constitution, especially Article 24, first two of the 1945 Constitution. So the legislation, there is five legislation as legal basis for religious courts. The first, law number 48 of 2009 on judicial power. And then law number 7 of 1989 on religious court. This is the first legislation, the first law for religious court to give basis, to give legal basis for institutionally for religious courts. Next, law number 3 of 2006 on the amendment of law number 7 of 1989, and then law number 50 years 2009 on the second amendment, and special in Aceh, law number 19 of 2001 on concerning special autonomy for a province of the special region of Aceh as the province of Nengro Aceh Darussalam. Of course, under the legislation, there are several regulation in presidential and canon and there are many regulation under legislation. Okay, this is the principle of Indonesian judicial system, the trial is conducted for justice based on belief in one on and only God. Or in Indonesia, demi keadilan berdasar ketuhanan yang maha. This is not only for judicial, not only for religious courts, because all of courts in Indonesian judicial system, but in your Supreme Court or Constitutional Court, have to conduct it for justice based on belief in the one and only God. And this phrase, this principle, have to express it, have to be expressed in the head of the decision of a court, every decision of court. State courts apply and enforce the law and justice based on Pancasila. This is the ideology basis for Indonesian judicial system. Pancasila is the state-based state fundamental for Indonesia. So all of law and all of courts in Indonesia must apply and enforce the law and justice based on Pancasila. So the Indonesian judicial system is conducted, implements implement the law of the Pancasila. The third, all courts throughout the territory of Republic of Indonesia. Sorry, this is the there are two words of Indonesia. Okay. All courts of the territory of the Republic of Indonesia is a state judiciary, which is regulated by constitution. It means that all court is have to be established based on the constitution. So there is no there are no court outside the constitution. Yeah. So in practice, maybe we know about the adat, the customary court in desa, in our village. So the adat tribunal, yeah, it is not part of courts as intended is Indonesian judicial system, because the adat tribunal have not yet regulated by the constitution. However, in law number 6 of 2014, is regulated. There is a regulation about the tribunal, the adat, and the adat tribunal, but the adat tribunal has not yet part of the Indonesian judicial system. This is the has not yet integrated to Indonesian judicial system. It is the special, the separation between the Indonesian judicial system and the adat tribunal in that practice in desa or in the village in village. The trial is administered in simple, fast, and low cost. This is the principle of procedural in Indonesian legal system, in Indonesian judicial system. Simple, fast, and low cost. Sederhana, cepat, dan berbiaya murah in bahasa. So every one who handling cases in Indonesian courts have to simple, have to be a service and simple, fast, and low cost. The second principle is independent and impartial. This is the universal principle of judicial system. Independent, no intervention. There is no intervention from legislative, from executive to judicial system, to court, to tribunal. And impartial, it is the neutrality attitude in principle of neutrality for judges in court. The next and then non-discriminative principle. It is universal principle, and in all of the judicial system in our world. So constitutional judges and judges are obligated to explore, follow, and understand the legal values and sense of justice that live in society. We call it this the sociological perspective, the sociological awareness of judges and constitutional judges. Every judges, both in constitutional court and tribunal and Supreme Court, have to explore, follow, and understand. Have to have the awareness about legal values and sense of justice that live in society. So every judges in one part, in one side, they have to awareness about belief about justice based on belief in the one and only God. This is the transcendent principle. And the other side, they have to awareness about sociological perspective. This is the balance of transcendent and sociological basis. And of course, every judge in constitutional judges and judges have to practice, have to subject to law, subject to legislation, subject to regulation, and of course subject to constitution. Constitutional judges and judges must have integrity and impeccable personality, honest, fair, professional experience in field of law. This is the requirement of judges in Indonesian judicial system. I think it is the universal of judicial system in our world. There is a standard in international judicial system about requirement of judges that is regulated in Bangalore Principle, the Bangalore Principle of Judicial Conduct. Indonesia, particularly Judicial Commission, and of course Supreme Court and Constitutional Court have used the Bangalore Principle as the standard for making code of ethics and code of conduct of judges. So based on the Bangalore Principle, and of course based on the Pancasila as the ideology of Indonesia, the constitutional judges and judges must have integrity, honest, fair, professional, and experience in field of law. This is there are several principles of Indonesian judicial system. All right. Right now we will explain about story of Indonesian religious codes. We start a story of Indonesian religious codes when Islamic kingdom periods. When Aceh, Mataram, Aceh Kingdom, Mataram Kingdom, Banten, Palembang, Siak, Pontianak, Banjar, Kutai, Kartanegara, Goa, Tidore, Ternate, Bima, and extra. There are many Islamic kingdom in Indonesia before independence, before the Dutch colonial came to Indonesia. And religious court is a legacy of Islamic kingdom, which spread throughout in Nusantara Islands, from Aceh to Maluku, to Maluku, and in Maluku, I think Tidore and Ternate is the oldest Islamic kingdom, and in Tidore and Ternate there is religious court in, of course, religious court in their kingdom, and Kutai Kartanegara is Islamic kingdom. However, also the Kutai Kartanegara has background in Hindu kingdom. Goa is Sulawesi, Bone and Goa and Bone in South Sulawesi. Siak, Palembang in Sumatra. Of course, Aceh, and Aceh after independence, Aceh after Reformation, after Reformation. After Reformation, Aceh has special autonomy to administer the religious court in Aceh. Particularly in Mataram Kingdom, Islamic court was famous as Pengadilan Sambi, terrace courts, because the courts was carried out in mosque terrace. So because when there is trial for Islamic people in Mataram Kingdom, the courts was carried out in mosque terrace, mosque terrace, and in Indonesia, in Java, we call Serambi. Yeah. Serambi foyer, Serambi means terrace or foyer, or veranda in English. After Islamic, after Dutch came to Indonesia, the Dutch people in Indonesia established the East Dutch Company, VOC, Vereniging Oost Company, Vereniging Oost India Company. Yeah, and when the East Dutch Company approached, there were efforts to abolish the religious court. This is not a politic of Netherlands, of Dutch government. This is pure the interest of East Dutch Company as a business company. Yeah. Because when VOC period, the Dutch company, the Dutch government was not rule in Indonesia. After VOC, yeah, approximately in 18th century, the Netherlands, India, the Dutch government come to Indonesia and make a Netherlands-India government in Indonesia. This is the period of Netherlands-India colonial periods, and during this period, the religious court were placed under the Landrat. Landrat is special court for indigenous people. Yeah, no, it is not people, but people. Yeah, which didn't have the authority of executor verklaring or executive declaration. The execution authority rests with Landrat. So, in the religious court is the part of Landrat, the part of Landrat, just only the part of Landrat, but the religious court have no execution authority. And based on Koninklijk Besluit number 24, Stadsblad 152, the Stadsblad stipulated that the authority of religious courts call the priesthood of Council of Ulama, Council of Religious Priests, remains in the field of the marriage and inheritance. This is the limitation of authority in religious courts during based on Koninklijk number 24, as well as the recognition and confirmation of existence and religious court that has existed before an Islamic law as a guideline. So the limitation, only the marriage and inheritance. And based on Stadsblad 1937, the authority of the religious court in Jawa Madura was reduced in property disputes, so that wakaf and inheritance were handed over to Landrat. This is the reduce of I think it is related to economic interest of Netherlands, India, of colonial, to limitation of Islamic people, limitation of limit to give limitation for religious courts to handle the wakaf and inheritance, to handle the about the economy, to handle the economy of Islamic people. So the wakaf inheritance were handed over to landlord, and in the consequence is in religious courts in Jawa Madura only has and have marriage and have authority on marriage and inheritance affairs. This is the significant reduce for religious courts in Java and Madura. In independence periods, in early independence, we know in January 1946, the Ministry of Religion was established, and all the affairs of the Islamic High Courts were transferred from the Ministry of Justice to the Ministry of Religion. This is the significant moment for Islamic for Islamic court or for religion court, because during the colonial, all of affair of Islamic high courts is handled by Ministry of Justice, and after independence, the affairs were transferred from the Ministry of Justice to the Ministry of Religion. So there is a separation between a general courts that's part of authority of Ministry of Justice, and religious courts, the part of Ministry of Religion. In early independence, there is law number 222 concerning registration and marriage, divorce and reconciliation, reconciliation of nikah, talak, and rujuk. Based on this law, the religious courts allows for a nationally consolidation of all marriage administration. This is the first time, the first moment for Indonesian state, for Indonesia, to consolidation of all marriage administration in one in one administration. This is the unification of marriage administration, and this gave a legal basis. This gave the basis, the administration basis to Islamic law for the future, until now. That is all of marriage administration is administered by the Ministry of Religion. In 1948, there is a law number 19 concerning the structure and powers of judicial bodies. There were only the 3 judicial bodies, namely general courts, administrative courts, and military courts. There is no religion courts. This is the setback of religious courts, the history of religious court in Indonesia. I think because many people in Indonesia, particularly the national group in nationalist group Indonesia, in Indonesia, has no interest in religious code, has no respects to religious code in Indonesia. But we will find in future, Sukarno is the leader of nationalists, have the different policy. In parliamentary government era, there is emergency law number 1 concerning temporary measure to organize unit of structure, power, and procedure for civil court. And in this law, religious court outside Java and Madura become part of Praja courts, sebagai Surakarta and customary courts. In Surakarta, in restricts besur gebid, which didn't remove and will be regulated by government regulation. Government regulation has only been issued for 7 years later. This is the regulation of concerning religious court outside Java and Madura. Okay. During Jahidid democracy era, in Sukarno era, this is there is a significant policy from Sukarno, because the Sukarno made law number 19 of 1964 concerning the basic provision of judicial power, and based on the law, there are 4 judicial spheres, 4 judicial circles, 4 judicial bodies. That are general courts, religious courts, military courts, and administrative court. And the first time, the Indonesian government, the Indonesian government give legal basis for religious courts. Okay, Mr. Syaifuddin, anything?
Yes.
We still have time.
20 until
Okay, 20. Yeah. Okay. The significant development is developed in New Order era or Suharto era. There is law number 14 that established 4 court circles, courts spheres as regulated in law number 19, 1984. However, the religious courts, military courts, and administrative courts are still special courts, not equal courts with general courts. And after that, the New Order made I think the historical law in Indonesia. The law number 1, 1974, concerning marriage, that strengthened the position of religious courts and the implementation of Islamic law. After, based on this law, the religious courts have a strong position to implementation of Islamic law in Indonesia. Okay. And a significant moment for Islamic from religious court is occurred in 1989 when Suharto issuance of law number 7 concerning the religious courts that provided a legal basis for realizing a religious court that independent and equal to other judicial spheres, to other judicial courts. This is the first law that regulated a religious court is in a spirited one legislation. This is the first time Indonesia have one legislation, one law that regulated religious courts. And after Reformation, this policy is implemented in amendment of the 1940 Constitution, has provided a constitutional basis for the existence of religious court in Indonesia. It is if we read article 24, verse 2, there is religious court as the one of religious circle, the judicial bodies, one of the judicial bodies under the Supreme Court. And the implementation of amendment is law number 2006 concerning amendment to law number 7, and law number 50 of the 2009 concerning the second amendment, law number 7. Okay. Right now we will expand the Indonesian judicial system in general. The judicial system power in Indonesia shall be implemented by a Supreme Court and judicial body underneath in the form of the general court, the religious court, military tribunal, and administrative court, and by us by one constitutional court. The Supreme Court, or Mahkamah Agung Indonesia in Bahasa, is the highest state court of the judiciary within the fourth judicial circle. For the judicial circles are general, religious, military, and administrative courts. The Supreme Court shall have the authority to hear and trial the highest cassation, the highest level or cassation, authority to review ordinances and regulations made under any law against such law. We call hak uji material or toetsingrecht in Dutch language. And this Supreme Court shall possess other authorities as provided by law, such as supervision and give a statement, give a not fatwa, fatwa for the other state institution. The General Court has the authority to examine, hear, and decide criminal and civil cases. Religious Court has the authority to examine, examine, hear, not try, hear, decide and settle dispute between Muslim people, only between Muslim people. The Military Court has the authority to hear and decide of military crimes. Administrative Court has the authority to examine, hear, decide, and settle administrative disputes. And there is a special tribunal that can be established in a court with under the Supreme Court. For example, Islamic Court in Aceh is a special tribunal within the religion court as long as related to religious court authority, and special tribunal within the general court as long as related to general court authority, particularly in Islamic criminal cases. Yeah. So this is the special tribunal for religious court and for the general court. Indonesian judicial system, no, I mean the constitutional court has the authority to adjudicate, and the first and last was decision is final to review the law against the 1945 constitution. It is the judicial review. Decide disputes the authority of the state constitution, that is the authority is given by the constitution. Decide on the solution of political party. Decide dispute about the results of the general election and other powers granted granted by law. In addition, the Supreme Court and Constitutional Court, there is a judicial commission. Judicial commission is part of judicial power, but has no authority to exercise the court. Judicial commission is not court. Judicial commission is commission with the authority to propose candidates for the Supreme Court justices, and other authority to preserve and uphold the honors, dignity, and conduct of justice. So judicial commission is part of judicial power, but no the court. The court is only Supreme Court and Constitutional Courts. The other bodies whose function are related to I mean the Constitution. The Constitution mention about other bodies whose functions are related to judicial powers, includes the inquiries and investigation. This is the police. Prosecution. This is the prosecutor. Kejaksaan. The implementation of the decision. This is the penitentiary, jail, or lembaga pemasyarakatan. Providing legal service. This is the advocate, and the settlement of dispute or out of the court, such as arbitration and mediation. Okay. The organization, administration, and finance of Supreme Courts and its judicial bodies under the Supreme Courts are under the authority Supreme Courts. This is the we call a one roof system of Indonesian judicial system. One roof system means when the organization, the administration, and finance affairs is integrated. I mean the organization, administration, and finance affairs of for judiciary. For the judiciary is religious, military, religious, and general, religious, military, administrative, all administered under Supreme Court. So the Supreme Court has one roof. This is the one roof system. I think this is the Indonesian characteristic of judicial system. I didn't. I have no ever the one roof system in the other countries. Okay, there is raise hand from who? Okay. Before 2004, the organization, administration, and finance of 4 courts were governed by Ministry of Justice for general courts and administrative courts, Ministry of Religion for religious courts, and Ministry of Defense of Security for military courts. And after 2004, all of organization, administration, and finance affairs of all judicial bodies is administered under the Supreme Court. This is different of with the Constitutional Court because the organization, administration, and finance of Constitutional Court under the power and authority of the Constitutional itself. Yeah. Okay. Structure of judicial bodies under the Supreme Court includes first level courts and appellate courts. General courts consist of the district courts that is located in the capital of regency and municipality with jurisdiction of a region of regency and municipality, and high courts that located in capital of province with jurisdiction cover region of province. There are some special courts in general courts, namely commercial courts, corruption courts, human rights courts, industrial relation courts, and fishery courts. Religious courts consist religious courts that is located in the capital of regency and municipality, and religious high court that located in capital of province. Particularly in Aceh, there is a special court within religious courts, namely Islamic courts, Peradilan Syariah, which consists of Syariah court or Islamic courts or Mahkamah Syariah in regency and municipality as the first level courts, and province Syariah court in the capital of province of Aceh as the appellate courts. However, all the Syariah courts for the cassation is undertaken in the Supreme Court as the highest court state in the Indonesian judicial system. Administrative courts consist of administrative courts and administrative high courts. And however, right now, only 4 high administrative courts have been established in Medan, Jakarta, Surabaya, and Makassar. In addition, there is a special court in administrative court that is taxation court. The military court consists military court, high military court, main military court, and battle military. This is the structure of the Republic Indonesia. Then we can see about the general court. We can see the judicial system. There is a Supreme Court and criminal constitutional court, and under the Supreme Court there are general courts, religious courts, military courts, and administrative courts. This is the judicial system, the structure of the judicial system. Maybe not too accurate, particularly in military courts, because military court and high military court sometimes there is there is authority for the first level court, high military court and high military court and military court. Particularly in religious court, there is Syariah court in Aceh and province Syariah court in Aceh. Okay. The jurisdiction of judicial courts. Religious courts are courts for the people who are Muslim. This is clear, not for the other peoples, the religion. The other religions. The religious courts are one of the state organs that administer of judicial power for justice seekers. In bahasa rakyat pencari keadilan, justice seekers who are Muslim regarding certain matters are as intended in the law. In law, I mean in the Islamic system, the Islamic law. Term justice seeker for in that term justice seeker in law of 2009 is everybody, not is everyone, both an Indonesian citizen as well as a foreigner who seeking justice in courts in Indonesia. So not only Indonesian Muslim citizen, but also foreigner, Islamic foreigner, is a Muslim foreigner from the other countries can can seeking justice in court in Indonesia. This is the justice seekers. Religious courts have the duty and authority to examine, decide, and settle cases at the level amongst people who are Muslim in the affairs. There are 9 affairs, 9 fields, then authority. An authority for the religious courts. The first, marriage or perkawinan, waris, inheritance, wasiat, testament, hibah, grant, wakaf, zakat, infak, sodakoh, and Islamic economy. The jurisdiction is in Indonesian religious court is, I think, is very huge jurisdiction. Yeah. Also, there is no criminal, but particular in Aceh, the Mahkamah Syariah in Aceh has the authority to decide, to hear, to examine, to decide, to settle the Islamic criminal law. However, it is special for Aceh, not for Indonesia or all Indonesia, not for the other religion in Indonesia. But when the jurisdiction religious courts give authority to Islamic economy, it is a significant development in religious court in Indonesia. In addition to those affairs, religious courts had special authority to give isbat of testimony, the ru'yat hilal, to determine the beginning of months in Hijri year system. Particularly every Ramadan, Shawwal, and Zulhijjah. However, Muhammadiyah is different because Muhammadiyah use the hisab, not ru'yat hilal. Okay, the term among people who are Muslim in the definition of jurisdiction of religious courts means a person, individual, or a legal entity, juridical person, such as limited company, state corporation, foundation, association, that automatically subject voluntary to Islamic law. Of course, regarding matter of the authority of the religious courts, in accordance with the profession law. So there, among people who are Muslim, not only a person, not only individual, but legal, but also legal entity, juridical person. The term marriage in definition in definition of jurisdiction includes that there are 22 affairs of marriage. The first, permission to polygamy, permission to marry to other than one. The second, permission to marry people for people who are not yet 21 years old. In the case of guardian parents, or not guardian parents, the trustee, or family, in the sideline there is a different opinion. Marriage dispensation, prevention of marriage, refusal of marriage by marriage registrar office, annulment of marriage, lawsuit for negligence, on the obligation of the husband and wife, divorce by talak, divorce suites, settlement of joint assets, mastery of children. A mother can carry the cost of maintenance and children education when the father who should not be responsible comply with it. Determination of the obligation to pay fees livelihood by husband to ex-wife, or determination of an obligation for the ex-wife, a decision of legality of child, decision on repeal of foreign rights or foreign powers, referral of the trustee, marital trustee, assignment of another person as trustee by courts in the case of his power as trustee is repealed. Appointment of a trustee in the case of a child who is under 18 years old that left by his parents. The imposition of obligation to compensation of children's property under his power, determination of origin of child, and determination of adoption based on Islamic law, decision regarding the refusal to give declaration for intermarriage, intermarriage between Islam and Christian, between Islam and the other religion, and statement about the validity of the marriage before the law number 1 of 1974 concerning marriage and undertake according to the other regulation.
For interrupting.
Yeah, okay. But Syaifuddin, Mr. Syaifuddin?
Yes, we have 5 minutes left for the presentation.
1 more minute?
5 minutes. 5 minutes.
Okay. So the jurisdiction of religious courts. What it means, the Islamic economy is an act or business activity that implemented according to Islamic principle, including Islamic banking. There are 11 affairs: Islamic banking, Islamic microfinance institution, Islamic insurance, reinsurance, Islamic mutual funds, Islamic bonds and medium-term securities, Islamic securities, Islamic financing, Islamic pawn shops, pension fund of Islamic financial institution, and Islamic business. There are the Islamic economy that is intended in the law of religious courts in Indonesia. The religious court can be formed special court that regulated by law. The term special courts refers to the differentiation or specialization in religious courts, such as Sharia arbitrary courts. So, in future, maybe in the religious court can be established the Sharia arbitration court, but arbitration courts, Sharia or Islamic arbitration court is a special court in the religious court. In special courts, could be appointed the ad hoc judges to examine, educate, and decide matters. The purpose of ad hoc judges, the purpose of appointment of ad hoc judges is to help settle cases that require special expertise, such as Islamic banking crimes. So when there is a case about banking, Islamic banking, and and a need for special expertise of Sharia banking crimes, the religious court can appoint the ad hoc judge to help the judges of religious court to settle the Islamic banking cases. Jadi particular in province of Nangro Aceh Darussalam, Islamic court established based on law number 18 that provide special autonomy to administer Islamic law in Aceh region. Islamic court in Aceh Darussalam has authority to examine, design, settle, or affair that regulated in religious court of law of 2006. So the all of affairs, the 9 affairs, yes, the 9 affairs that's regulated in Religious Code 2006 have to become also as the authority of the Islamic court in Aceh Darussalam. However, based on the law, based on the law 80 of 2001 and Canon of Aceh Province number 10, 2002, the Islamic court in Aceh Darussalam has special authority to hear, to examine, to decide Islamic criminal cases, jinayats. Yeah. This is the special court, and according to the law number 40, the law number 15 of 2009, the Islamic criminal cases is not part of religious court, but this is the special court for general courts. Okay, judges of religious court. Judges in religious courts have special requirement, that is, must be a Muslim. Must be a Muslim. Non-Muslim cannot be judges in religious courts. And judges in religious courts have background in Bachelor of Sharia, Bachelor of Islamic Law, or Bachelor of Law who has competence in Islamic law. Yeah. It is the special requirement for judges in Islamic courts. Judges of religious court is required by Supreme Court with requirement of the minimum ages 25 years old and maximum ages 40 years old, and can be pensioned at 67 years old as high judges and 65 as judges in first level courts. And based on need in Chamber of Islamic Courts, in Supreme Court there is a chamber special for Islamic Court. There are four. There are 5 chamber in Mahkamah in Supreme Court. Civil chamber of civil court, civil law, chamber of criminal, chamber for administration, chamber for military, and chamber for Islamic courts. And justice, based on need of chamber Islamic courts, justices in Supreme Court must be selected from judges of religious high courts. And justice have term of office until 70 years old. This is the last slide. Procedural law that applies to religious courts in the civil. Procedural law that applies to the religious court is the civil procedural law that applies to courts within the general courts. So it is the same procedural law between in a general court and the religious courts, except that specifically regulated in the law. I mean the law of religious courts. And there are many regulations about the procedural law in a civil procedural law. Handling case in religious court is also facilitated by the support of e-court services. And e-court services consist e-filing, e-payment, e-litigation, and e-summons. So if we have cases in religious courts, can be facilitated by support of e-court services. Okay, Mr. Syaifuddin, I think enough. Yeah, and after that we can discussion. Thank you. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh. This presentation from Prof. Aidul Fitriciada Azhari. Thank you for your very insightful presentation. Now we come to the next section, that is question and answer. In chat, we can see there are 3 questions. Firstly, from Mr. Budi Santoso, and the question is, what are the main problem with the practice of the religious court system in Indonesia? So, secondly, from Mr. Kim Jiwon from Korea. Thanks for the great presentation. I'd like to ask, in your opinion, do the religious court in Indonesia have an important position in the law enforcement? Has its presence been in accordance with the needs of Indonesian people in general and not only Muslims? Thank you in advance. And third, from Mr. Iwan Sanjaya, I heard earlier that you were the chairman of the Judicial Commission, the institution that oversees the judiciary in Indonesia, including the religious court. Based on your experience, can the religious court in Indonesia work more effectively in solving problems faced by citizens than the general court? Is it true that the judiciary for Muslim religious court should be sparred from other religion or religious community? And the last, for Mr.
I can hear.
In the chat, Prof, permission to ask Prof, Aidul, regarding the interfaith marriage that have occurred in Indonesia in recent time, how does the applicable Islamic law affect the resolution of this problem?
Mr. Syaifuddin, I cannot hear your voice. Yeah.
Okay. May I repeat once more? Okay, may I repeat once more, Prof?
Yeah, I have to answer the first in chat. Okay, in the question in chat, Mr. Syaifuddin.
Yes, in the chat we can read the question.
Okay. Well, the first question: what are the main problem with the practice of the religion courts system in Indonesia? In my experience, in my observation, as when I was in Judicial Commission, yeah, I think the religious court in Indonesia is, in quote, is the best course in Indonesian judicial system, because the competency of judges in religious courts, not only in general law, but also in Islamic law, and Islamic law needs a competency and needed skill in Arabic language, in Islamic jurisprudence. So the basic of Islamic law studies can help to strengthen the competency of judges in religious court. So I think the problem in practice right now is in procedural law, yeah, because there is no special procedural law in Indonesia, and procedural law in there is no procedural law in religious court in Indonesia, yeah, in one legislation, in one law, because the procedural law in religious court have to subject to private law, yeah, as practices in general court. So I think the problem is the main problem is the in procedure law. Yeah. Okay, this is from
Mr. Budi Santoso.
Budi Santoso. Okay. So in my observation, also in my observation is of the religious code in Indonesia is the best, yeah, because I see in I observe in competency in this and verdicts, yeah, in decision of the religious code is very good. This is yeah, this is very good. Yeah. Okay, this is from Kim Ji-won from Korea. Yeah. Thanks for great presentation. I'd like to ask in your opinion, do the religious code in Indonesia have important position in the law enforcement? Has its present been in accordance with the need of Indonesian people in general and not only Muslim? Thank you. Yeah, in my opinion, the religious code in Indonesia have important and significant position in Indonesia because Indonesia is the country with the youth population, youth Muslim population in the world. So the Muslim people in Indonesia need the special courts, and the religious court. The religious cuts give a significant position for the Muslim people in Indonesia to achieve their interest in Islamic and in Islamic affairs. When has his present been in accordance with the Indonesian people in general and not only Muslim? This is I have my friend that's make dissertation about Islamic banking. Yeah, Islamic banking in Indonesia. So there is information that is there is facts that maybe more than 60% of Islamic banking Islamic banking user is not Muslim. Okay. So the problem is when the problem is when the consumer of Islam of non-Muslim in Indonesia that use the Islamic banking or Islamic institution, Islamic economic institution, have dispute with the Islamic institution. So it is the problem. It's the problem because the religious people, the religious code only for Muslim people. So when there is problem, there's a dispute between Muslim and non-Muslim, of course of course has to settle in general courts. But for Muslim people, there is no choice. In Islamic in Islamic law, in Islamic affair that's regulated in the law. to use to settle their affair in the other courts, yeah, then except the religious people, religious courts. But however, yeah, for Indonesian people, particularly for Muslim people, yeah, and of course the jurisdiction of the religious court is limited, yeah, limited on 9 affairs, not only in 9 affairs. Yeah. So for Muslim people is important. It's important position, important role for the Muslim people to settle dispute, settle dispute related to 9 affairs as intended in the religious court law. This is in my opinion. This is the point of my opinion. So not only all the legal affairs, yeah, only in limited affairs that is intended in the law, in the religious court law. But when there is affairs between Muslim and non-Muslim, of course, we have to settle in. We have to come to general courts, not to religious courts. This is in my opinion. Yeah. Iwan Sanjaya, I heard earlier that you were the chairman of the institution that oversees of judiciary in Indonesia, including, okay. Based on your revision, can the religious court in Indonesia work more effectively in enforcing problem first? This is not, I think it is not comparison, not comparison point, yeah, because the general courts and the religious court have the different jurisdiction, yeah, the different jurisdiction, or the religious court have the limited jurisdiction, but the other jurisdiction, the other affairs, we can come to general court. It is not for comparison. Yeah. But however, for Muslim people in Indonesia, also the religious court is very, very important. Yeah. This is the I think this is the interest, the long interest of Muslim people in Indonesia to strengthen the existence of religious court, because in development of Muslim people in Indonesia, that change to that have a mobility of that have social mobility for the agricultural people to industrial people, yeah. And when the Muslim people come to Indonesian, change to Indonesian people, they require a special interest to settle several affairs, yeah, related to his religion, related to their religion as a Muslim. For example, there is economic Sharia or Islamic economic. This is the development of religious code in Indonesia after Reformation. After Reformation, and it is the development is began by the social mobility of Muslim people in Indonesia during Orde Baru, during New Order, during the order that can that change for the agriculture to industrial spares. When they come to industrial people, they need a special business special economy in Islamic affairs. So in after formation, there is a development in our law, in Indonesian law, about the religious course that regulated jurisdiction of your religious code in economic Islamic economy. This is part of development of social of Muslim people in Indonesia. So when you ask about more effectively in solving problems by citizen than the general court, it is not comparable, because religious court is give service to Muslim people in limited affairs, and the general court is I think there is there are many affairs that can settle in general court, because the jurisdiction between the jurisdiction of between general court is religious court is different. This is in my opinion, the point of my opinion. Okay. So who is Reza of area? Regarding the interfaith marriage that have occurred in Indonesia in recent time, how does applicable Islamic law affect the resolution of this problem? Okay, based on our legislation is clear. Yeah. There is no interfaith marriage, but in practice, this has been practiced based on the decision of Supreme Court. There is a case when the Supreme Court give like a dispensation for spouse to marriage in Indonesia with the provision that the each man and female, their spouse, can have not yet subject to Islamic or to religion law, to religion law. So there is based on legislation is clear, but in practice, there is a spare to interfaith marriage in Indonesia. So I think there are many interfaith marriage in Indonesia, intermarriage in Indonesia, and particularly in Java. In Java, I think in Java there are many interfaith marriage in Indonesia, but we can separate between the legislation and the practice in Indonesia. And in practice, in legal practice in Indonesia, based on Supreme Court the verdict, there is a spare. There is dispensation for supposed to interfaith marriage. Yeah, this is not only Islamic law. This is, I think, this is a national law. Yeah, because if we read the legal reasoning of Supreme Court's verdict, there is consideration about that based on the legislation, there is no the interfaith marriage is prohibited. Yeah. But however, Supreme Court give consideration. In practice, there are many interfaith marriage. So law and justice in Indonesia cannot have to give opportunity, yeah, and cannot to illegal marriage and cannot to or omission and cannot to give spare to legal marriage to illegal marriage between in practice. So the Supreme Court, in the consideration of Supreme Court, finally give as legalization of, I think not legalization, it is opportunity. Yes, I think it's legalization about the interfaith marriage. So there is two perspectives. Yeah, based on legislation, it is clear. Yeah, but in practice, there is a special case. This is in like dispensation for people, yeah, for spouse that conduct the interfaith marriage in Indonesia. Yeah, I think we can read the verdict of Supreme Court Indonesia, but I forget number. Its number. Yeah. Okay. Syaifuddin Zuhdi. No? Abdullah. Yeah. That's okay. Does government has a political or religious court to register Islamic law place? Is it still impact for no? No, because based on according to amendment of the our constitution, the religious court is regulated in constitutional provision. Yeah. That is in Article 24, verse 2 of our constitution, of Indonesian constitution. So I think and it is the development, the significant development of religious court in Indonesia, and not only the position, but the jurisdiction is different from the colonial era. In the colonial era, the religious court is limited in marriage, yeah? And today, right now, the religious court, the law give to the religious court an authority, a huge authority, yeah, in 9 affairs, includes the economic, the Islamic economic. So I think it is different. It is not no impact for of the Netherlands India policy to now. Yeah. Okay.
Okay, thank you,
Yeah.
Prof. Aidul.
Any question?
Maybe enough, Prof. The time is up.
Oh yeah. One
Okay.
more night. One more. One more minutes. Yeah.
Okay, we come to the end of this session because the time is up. But before the closing this session, I would like to express my deep gratitude to Professor Dr. Aidul Fitriciada Azhari S.HI M.Hum for taking the time today and willing to join us in international short course with the topic the dynamic of Islamic law. Thank you so much, Prof.
Yeah. Thank you.
Okay. Finally, we come to the end. To close this session, let's reciting Hamdalah.
Alhamdulillah.
Alhamdulillah.
Thank you.
Okay. Ladies and gentlemen, and especially the speakers, thank you very much for joining us today. I will close this session with Wassalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam. And good morning.
Okay, thank you, Prof.
Thank you. Thank you. Thank you. Okay, I will leave it, Mr.
Yes.
Syaifuddin.
Thank you,
Yes,
bro.
yes. Thank you, Prof.
Uh,